This is Brent Allen Winters. CommonLawyer.com, www.commonlawyer.com, coming at you from the remote hinterlands of the Wabash River Valley, where the hogs, the frogs, and the dogs keep up the racket all night long. Well, let's go to the few questions here. 179 from the Catechism on the Constitution of the United States. Stansbury's Catechism, 333 questions. Question 179. May states of the United States, any two states or more, make a treaty or agreement with any other nation? May any one of the states of the United States make a treaty or agreement with any other nation according to the terms of our Constitution? Answer: no. It's unlawful. It's unconstitutional. Why is it unconstitutional? Because our Constitution is a brief of common law government. It's always been contrary to our common law tradition for a nation to do that, such as England. So no county, no shire in England was supposed to be making deals with other countries. No, that is the exclusive jurisdiction of the national government of our, and by the way, other nations, and our Constitution says Indian tribes. States are not to make deals or treaties or agreements with Indian tribes. Those are separate nations, according to the terms of our Constitution of the United States. Question number 180. May any state make war with another country? Answer: no. Unless, and this is an important caveat, unless an enemy has entered their bounds or is in danger of entering that state. And the federal government, if Joe Biden was in office, Texas was being invaded by not thousands or tens of thousands, but hundreds of thousands, even maybe closer to millions. We don't know, but that was a lot. And if the general government in Washington, D.C., Joe Biden wouldn't do anything about it, Texas had every responsibility to mobilize the National Guard and the militia of the state of Texas, which includes every able-bodied male over at least 20 years old, and stop it. That's why the governor of Missouri, was being invaded by people coming over from Texas. And he sent part of the National Guard, he mobilized them in his state and sent them to the Mexican border. Why? Because they were bringing fentanyl, invading his state with fentanyl, and residents and citizens of the state of Missouri were dying. That's constitutional. That's the way it works. Remember, make it simple. There are two men at any given time in the United States who have authority to take command of the National Guard of that state or the militia of that state. Either the governor of the state or the president of the United States. Case in point. So-called riots somewhere in Los Angeles. Newsom claims to be governor there. He wouldn't do anything. Property was being destroyed. Looting was occurring, private property being stolen. The federal courthouse was being threatened. I practiced law in that federal courthouse. Come to think of it, I'd forgotten about that. That thing, if you really did arm it from the inside, there was no way anybody could get in. That thing is solid, boy. When I was there, brass doors, brass railings, stones this thick. They didn't spare any money building that building. That's federal property. That's property of the United States. If it's being threatened, and it was, and the governor of the state would not mobilize the National Guard to stop the madness, the looting, destruction of property, the insurrection, then the president of the United States had every authority to do that and did so. So what did Newsom do? He filed a lawsuit in the federal district court there. Again, that courthouse, I'm familiar with it. And judge there, a brother to former Supreme Court Justice Stephen Breyer, however his name is pronounced, B-Y-E-R or something, ruled and said that the President of the United States, D.J. Trump, had no authority to mobilize the National Guard without permission from Governor Newsom. Is that true? Well, it went straight to the Ninth Circuit Court of Appeals, and they reversed it, said that's silly. Well, of course it's silly. That's the kind of folk you got sitting on the bench, and that is what ruins respect, natural respect for our courts. I mean, if they're not even trying, these guys are trying to do whatever they want to do to politicize the courts, and the law doesn't matter anymore. That's what that judge did. Here's the way it works, friends. It's always been this way in America. We didn't used to have a National Guard. We had the militia. If the president wanted to mobilize the militia to do three things: stop invasion of the United States, stop insurrection within the United States, stop or enforce United States law of the United States, he had authority to do that, unless the governor had already mobilized the National Guard in his state. If Governor Newsom had already mobilized the National Guard to stop, or whatever he wanted to do, then whoever does it first, the president or the governor, whoever does it first has command of the National Guard. In 1957, 57? Yeah, 57. I think the court case, Brown versus Board of Education, was 1954. A U.S. Supreme Court case said, no, you got to let this little girl named Brown, who, by the way, was a brown girl. No, she wasn't black. Very few of the people that call themselves black are black. They're brown. And a little brown girl, and her name was Brown. In high school, I think, and she wanted to go to a school that was all white. Well, governor, his name started with an F. The governor of Arkansas, there in Little Rock, wasn't going to enforce the Supreme Court's ruling. He never mobilized the National Guard. President Eisenhower took command of the National Guard. Well, that's lawful. He did it first. That's it. The other guy, Fobb, I think his name was Fobb, something like that. If he would have mobilized the National Guard, he would have had command of them. That's the way our law works. If he'd have mobilized the militia, he'd have had command of them. If he'd have mobilized part of the militia of the state, and then the president said, well, I'm mobilizing the other militia that you didn't mobilize out of the other counties, well, that would have been okay too. Or I mobilized this part of the National Guard, and then the president said, well, I'm mobilizing this part. But if the president comes along like Eisenhower, and mobilized the National Guard, he's got command of the National Guard, and they become part of the armed forces of the United States at the point of his order. That's what happened in California. And the Ninth Circuit just said that. Yeah, that's the way it's supposed to work. It's always worked that way. Shut up. What there has to be, it has to be a constitutional reason. I gave you those three reasons. Constitution says that of the militia of the United States. The federal statute, real short little statute, it says that about when the president can do that. Of course, he's got to make sure if the governor has already mobilized the National Guard or any part thereof, he can't mobilize that. He can't take command over that. But the governor didn't. He was hoping there would be riot, chaos, and more destruction. That's what the left thrives on, disorder. It is politics of chaos, because that's the only way they can have any power. They can't have it through an honest election. They've got to create chaos. like most Democrats, they can't even stay in office unless they can start a war, because that creates fear. That's what Roosevelt did. That's what Woody Wilson did, World War I, to get what he wanted in other ways. People are just loath to change presidents once a war is going. Sick, isn't it? Yeah, it is. That's what we have to guard against. If we've got enough sense, we won't let that happen. But coming back to the point, the Constitution of the United States, Governor Newsom had authority. If the president wouldn't try to do something about the border and the illegals invading California, Newsom had a duty to stop it using the National Guard or the militiamen of his state. He didn't do it. We have these different levels of president, governor. In case one fella doesn't do his duty, maybe the other one will. It's like Sheriff Darr said when we were teaching the law course about the sheriff of common law and the posse, the power of the sheriff. If the police chief of Seattle doesn't bring order to the rioting in Seattle, then the sheriff of that county has an affirmative duty, a non-delegable duty to come in with force and stop the madness. He didn't do it. Well, this according to a sheriff that's been sheriff for a lot of years. His office trumps that of the police forces of any particular city, especially if they won't do their job. And that's what was going on there, and that's what went on in California. Newsom wouldn't do his job, so the president, he picks up the baton and runs with it. And the appellate court, sitting there in San Francisco, agreed and said, yeah, he did the right thing. May the states make war? Answer, no, unless an enemy has entered their bounds. People pouring across the border, bringing fentanyl and who knows what else. Or unless such danger of entering the state, and there is no time to wait for the aid of the general government. I'm reading general government. That's what they used to call the federal government. Good thing. General. Let me fix this thing a little bit. General government of the United States. Why did the states give up this possibility of power to the general government of the United States? Answer, because they could be better protected by one powerful government ruling over them all united than they could have been if they had remained separate. And if they would have such a government, they must consent to give up a part of their own power in order to allow it. If the general government, that's the one in Washington, D.C., had no power, it would be of no use. Somebody's invading. When people invade, if somebody did invade, like when we invaded Normandy, when we invaded Europe, we invaded a very small area of beach compared to the coastline of France. Very small. Entry point was small. That's the way invasions of countries occur. But even though it was a very small area, in one day, about 175,000 American, Canadian, and British troops invaded. And then D-Day plus 2, D-Day plus 3, they just kept pouring in. But they poured in one place. We have a general government in Washington, D.C., so that if that happens, that general government can muster the force of the whole United States, the whole United States militia of every state, the National Guard of whatever they think they need, and the armed forces of the United States to stop that kind of a massive invasion, maybe at one point or two, wherever we give the President of the United States that option and hope he takes it. If he doesn't, we have to slug it out ourselves. I talked to a fellow last night that works in the Pentagon. He's been there, he's over 20 years in the service, and his job is to do research and advise the Secretary of Defense. That's his job. He said, Brent, I don't do anything but read law And the Congress has passed a lot of laws about how to go to war, what we're permitted to do, when we can do it, what weapons we can use. And my job is to read all this and keep taking notes and cross-referencing and advising the Secretary of Defense. That's the job of the general government, to be ever ready. And the more ready you are, the more you sweat in peace, the less you bleed in war. The more he studies, the more they understand, the more they contemplate what they can do if this happens or that. The more they worry over it like a dog worries over the bone, the better off all of us are going to be. That's why we do that. But if a president such as Biden fails to do that, and he failed, friends, and those state governors down there along the Mexican border had every constitutional authority where the president fails to pick up the reins and stop the madness, and some of them did, including, as I'd mentioned, the governor of Missouri, because they were invading his state. So he went down to the border, of course, talked to Texas about it, said, well, it's okay, oh yeah, come help us. They didn't make an agreement. That's forbidden. Our Constitution forbids that. But they went down there. They said, can we come down here and just do what we need? Oh, yeah. This is Brent Allen Winters. CommonLawyer.com, www.commonlawyer.com, coming at you from the remote hinterlands of the Wabash River Valley, where the hogs, the frogs, and the dogs keep up the racket all night long.